Immigrant visa process. How can I get prepared for my interview?
Tell us, what can an applicant do to prepare for an immigrant visa interview?
The best way to prepare for your immigrant visa interview is to know what items to bring, when to arrive, and what to expect. Applicants should plan to arrive at their appointment time. The embassy opens for operation at 7:15 a.m. Applicants are not admitted into the building until that time. It is not necessary to arrive before your appointment time or before our office opens. Once you arrive, you'll be screened by security. Please note that no cell phones or electronics can be carried into the embassy, and there is no storage available at our location. Please make arrangements for these items before arriving. When you enter the building, you will be given a number in the queue. Consular officers and staff will use this number to call you for your interview, and an electronic announcement and monitor are on display in the waiting room to let you know when it is your turn.
So what documents do applicants need to bring?
All applicants should bring the documents listed in their appointment letter, if they were not already submitted with your visa application. These include police certificates, medical exams, birth and marriage documents, and financial sponsorship paperwork. If a fiancé or spouse is petitioning for the applicant must bring evidence of a relationship with the petitioner. Examples of this evidence may include photos, phone records, letters, emails, money transfer receipts, and copies of the petitioner's passport showing their travel between the U.S. and Jamaica. Every applicant with a previous non-immigrant visa should also bring in the passport containing that old visa. Each applicant needs to have passport photos, a current passport, and the medical report.
What should applicants expect once they arrive in the building?
Each applicant is pre-screened, which includes collecting documents and fingerprinting. After pre-screening, applicants are interviewed by a consular officer to determine if they meet the requirements for their specific visa category. What is a joint sponsor and why do I need one?
Many applicants have questions about sponsors and financial requirements for immigrant visas. Can you explain a little about this?
One of the most common reasons why an immigrant visa applicant must return for a second interview is the failure to provide adequate financial documents from their sponsor. U.S. immigration law requires that each immigrant have a sponsor in the United States who has adequate income to support the immigrant. These income requirements are published each year and are based on family size. For example, a single person in the U.S. who is sponsoring a single person from Jamaica will have a household size of 2 people, the person in America plus the immigrant. In 2012, the income requirements for a person household with 2 people was $18,912 US. For each additional person in the household, the income requirement increases. There is a chart available online through the U.S. Citizenship and Immigration Service website, which lists the income requirements.
And what is that website?
The USCIS website is www.uscis.gov. One can find the specific chart by searching poverty guidelines in the search function.
What happens if the person that filed the immigrant visa petition does not meet the income requirements?
If an applicant appears for the interview and the person that filed for the applicant does not meet the income requirement, the applicant will need to find a joint sponsor. A joint sponsor is someone in the United States, either a friend or family member, who is willing to accept certain financial responsibilities for the applicant from the time the applicant enters the U.S. until the applicant becomes a U.S. citizen. If a joint sponsor is required, the consular officer will provide the applicant with a list of required documents.
How do applicants follow up on their cases if they need a joint sponsor?
The joint sponsors documents should all be sent directly to the embassy in Jamaica. Once the documents have been received and approved by a consular officer, the applicant will be contacted to bring in their passport so we can continue processing the visa.
Is there ever a situation where you will consider several people's income in combination for sponsorship purposes?
There are certain situations when we can take combined incomes into account. If a sponsor shares a household with another person who is the child, parent, or sibling of the sponsor, that person's income can be added to the sponsor's income, and the consular officer will take the total combined income into account. For example, if the petitioner or the joint sponsor is married, his or her spouse can complete paperwork as a household member, and the consular officer will consider both incomes. Why was I asked to return with additional documents, and what should I do now?
Quite a few people seem to leave their immigrant visa interviews with blue or yellow sheets of paper. What are these blue sheets and what do they mean for an immigrant visa application?
Each visa applicant is required to have certain documents for their file before a visa can be issued. For example, applicants must present a birth certificate, a current police certificate, medical exam documents, and financial documents from their sponsor. If an applicant is missing any required information at the time of their interview, the consular officer will fill out a blue or yellow sheet of paper explaining exactly what items are missing and how to schedule a follow-up appointment to provide the missing information. The yellow sheet is given to applicants who need to have documents mailed in from the petitioner or joint sponsor in the United States. The sheet contains the embassy's mailing address, where the U.S.-based family member can send us the documents via international courier service. Once we receive those documents via mail, we will contact the applicant to come into the embassy to drop off their passport.
Do you see any common problems with visa cases?
There are a few. Applicants should be sure that they have the required police certificates, civil documents, and financial documents. First, applicants must make sure that their police certificates are current at the time that they will travel to the U.S. Police certificates remain current for 1 year from the date they are issued. If your police certificate will have expired by the time of your interview or by the time you plan to travel, you should be sure to bring a new police certificate to your interview. Second, applicants must be sure to bring all the necessary birth and marriage certificates. If the petitioner or the beneficiary has gotten married and changed their name, we need to see a marriage certificate documenting that name change. All Jamaican marriage certificates must be from the Registrar General's Department and on the new security paper. We cannot accept the older handwritten certificates. Finally, applicants should make sure that they have all the required tax documents. All sponsors must provide their most recent tax returns and W-2 statements. Applicants should be sure that their sponsors have provided either a photocopy of their tax returns and their W-2 statements or their income tax return transcripts, which can be ordered online from irs.gov. Even if you think that your sponsor has already sent his or her tax returns to the National Visa Center, it is helpful to bring extra copies to your interview just in case the documents previously submitted were incomplete or incorrect.
Do applicants have to restart the whole process if they are given a blue or yellow sheet at their first interview?
No. In fact, in some cases, the applicant can simply drop off the required documents, along with their passport. In other cases, the applicant will need to schedule an appointment to speak with the consular officer to have their information reviewed. In either situation, these follow-up appointments are scheduled by email. The blue and yellow sheets provide specific instructions, and it is important that the applicant follows them and completes the application process in a timely manner. Visa fees are valid for 1 year from the date of the initial interview. So it is very important that all documents are submitted and all necessary follow-up appointments are made within this time frame. DNA and how to complete the test.
Why would a consular officer suggest a DNA test as a part of an immigrant visa application?
Most immigrant visas are issued based on qualifying family relationships. For instance, a parent can petition for a child can petition for a parent, and a sibling can petition for a sibling. During the interview, the consular officer must be convinced that there is a qualifying relationship between the petitioner and the applicant. In certain situations, when the consular officer is not fully convinced that there is a relationship between the petitioner and the applicant, the consular officer may suggest that a DNA test be performed to confirm the relationship.
And if the DNA test is suggested, how and where do people get tested?
The instructions for the DNA test are provided by the consular officer. The petitioner requests and pays for the test online according to the instructions that the consular officer provides. The petitioner can complete the test in the United States. All applicants, however, must come to the embassy for their portion of the test. After the petitioner orders the test kits, the kit for the applicant takes about 2 weeks to arrive at the embassy. Once the test kit arrives, the embassy contacts the applicant to schedule a testing date and time.
What should people expect when they do a DNA test?
The test is not invasive. It involves wiping a small cotton swab on the inside of the mouth of the applicant. After the test is completed, the test kit is returned to the U.S., and the results of the applicant's test analysis are compared with the petitioner's test results. The final analysis of the results is reported directly to the consular section at the embassy and also via letter to the petitioner. If the results confirm the relationship, a consular staff member will contact the applicant and notify the applicant if any additional documentation is required. In many cases, once the relationship is confirmed by DNA evidence, the applicant only needs to return to the embassy to drop off their passport so that their visa can be issued. If the results do not confirm a biological relationship, the applicant is notified by letter or in person that they will not be able to travel to the U.S. on the petition. Returning petitions to USCIS.
Sometimes people are sent away from the embassy without a blue sheet to-do list and are told that the petition is being returned to U.S. Citizenship and Immigration Services for review and possible revocation. When does this happen and why?
This generally occurs when the officer has serious doubts regarding the legitimacy of the relationship between the petitioner and beneficiary. If the officer does not believe the relationship is valid and legitimate, the petition is returned to USCIS for review and possible revocation.
So what happens after the petition is returned to USCIS?
The consular officer always works with the applicant to get as much information as possible before sending a case for review, since our goal is to issue visas to qualified applicants and help to reunite families. If it is not possible to issue the visa and the petition is returned, USCIS reviews the case. At this point, one of several things can happen. First, USCIS might determine that all documentation is sufficient. In that case, USCIS will ask the embassy to continue processing the case. Second, USCIS might decide that additional information or documentation is necessary. In this situation, USCIS will contact the petitioner by mail and request the necessary items. Lastly, USCIS might determine that there is not enough evidence to support the application and move to revoke the petition. If USCIS revokes the petition, then the petition is canceled and no visa can be issued. Even in this case, the petitioner is given a chance to appeal the decision and submit evidence that might prove the validity of the relationship and make the case issuable.
How can applicants contact the embassy to check on their case?
Once the case is sent for review by USCIS, the embassy no longer holds the file, and applicants or the petitioners should contact USCIS to check on the status of their case. Visa ineligibilities and waivers.
I have heard the term waiver used in regards to visa applications. Can you explain what a waiver is and who needs one?
There are certain ineligibilities that can prevent a person from qualifying for a visa. U.S. immigration law establishes these ineligibilities. Some examples of ineligibilities are previous overstays in the United States, illegal entry into the United States, use of a controlled or illegal substance, or crimes involving moral turpitude. This also includes crimes such as theft or fraud.
So, if an applicant is found ineligible, is there any recourse?
Under certain circumstances, there may be a waiver available, but it depends on the type of ineligibility and whether or not the applicant has a qualifying family member in the U.S. If a waiver is available, the decision to approve or deny that waiver will be made by the U.S. Citizenship and Immigration Service.
How do you apply for a waiver?
Waivers are processed by U.S. Citizenship and Immigration Services. Applicants who are eligible to apply for a waiver must fill out a waiver application, Form I-601, and submit the application and fee of $585 to one of 2 USCIS lockboxes in Phoenix, Arizona. The consular officer will provide an information sheet containing further instructions at the time of the interview. Instructions can also be found on our website.
How long does it take to get a waiver?
Each case is different, and it is difficult for us to predict how long it will take USCIS to approve the waiver. However, applicants usually receive a response within 1 year. It is important to know that there are no guarantees that a waiver application will be approved. The outcome of the application depends on the specific circumstances of the case.
What happens if an applicant applies for a waiver and it is approved?
If a waiver is available, applied for, and approved, the embassy will follow up with the applicant to update their case file and all documentation so that the visa can be issued. Rollbacks.
Sometimes applicants hear that the processing of their cases have been affected by something called a rollback or a retrogression of visa numbers. It is my understanding that when this happens, some applicants who are interviewed months ago and asked to provide additional documentation are not able to continue their application immediately. Can you explain?
To understand what a rollback is, it helps to understand how the immigrant visa process works. For certain categories of immigrant visas, U.S. law imposes a numerical limit on the number of visas that can be issued in a year. It is important to know that there is no annual limit on the number of immigrant visas that can be issued to spouses, minor children, and parents of U.S. citizens. It is also important to know that there is no limit on the number of non-immigrant or visitors visas that can be issued in a year. However, there is a numerical limit on the number of immigrant visas that can be issued in other relationship categories, for instance, to adult children of U.S. citizens or to children of legal permanent residents. In these categories, all applicants are assigned a priority date. This is the date that their petition was filed. The availability of an immigrant visa is based on this priority date and the annual number of available visas for the specific category of family relationship.
So if a person's petition is filed, for example, on April 1, 2000, is that their priority date?
Yes, and this priority date is used to determine when the person can be interviewed for a visa. Each month, the Department of State publishes a bulletin of immigrant visas that are available based on priority dates and category. For example, as of September 2012, we are interviewing and issuing visas for unmarried adult sons and daughters of U.S. citizens with a priority date of October 1st, 2005 or sooner. Therefore, if a petition was filed for an unmarried son or daughter any time before October 1st, 2005, that person is now eligible for a visa interview.
If this is the process, why are rollbacks sometimes needed?
The Department of State's bulletin estimates how many visas will be available each month, and we schedule interviews accordingly. Because it is impossible to predict exactly how many visas will actually be issued in a month, this is not an exact science. At the beginning of 2011, for instance, the Department of State saw that a large number of visas had already been issued in certain categories, and as a result, rolled back the cutoff dates for certain categories. The visas for adult sons and daughters of U.S. citizens, for spouses and children of legal permanent residents, and for brothers and sisters of U.S. citizens were all affected by this rollback.
How would an applicant know if he or she is affected?
If an applicant's file is affected by a rollback, he or she will be contacted by the embassy. The embassy will hold the file and check each month to see if the priority date is current, and an interview can be scheduled. Unfortunately, we cannot predict when these cases will be current again.
What does an applicant need to know? Or what does an applicant need to do about their file?
Depending on the length of time it takes for a case to be current again, an applicant may need to update the documents in their file, such as the police report or medical exam. The embassy will advise each applicant of the required documents, if any updates are needed, and when a follow-up appointment is scheduled.
Is there any additional information that applicants or petitioners should know about the process?
The U.S. Embassy strongly encourages petitioners and applicants alike to read through the paperwork very carefully and be as prepared as possible before the date of the immigrant visa interview. It is imperative that petitioners and applicants fill out and submit all necessary documents before the interview date or on the interview date. Failure to do so will cause delays as to the issuance of the visas, and more importantly, can cause applicants to pay additional fees in the case a document in their file expires. Fees and case termination.
Do applicants have an unlimited amount of time in which to take action in their case once the petitions become current?
Applicants do not have an unlimited amount of time in which to take action on their cases. According to U.S. immigration law, there are two ways immigrant visa cases end up in a termination status. First, the case expires if the applicant does not make an appointment within 1 year of receiving the appointment letter. Second, U.S. immigration law states that if an immigrant visa applicant does not make an attempt to overcome their refusal within 1 year of being refused, the case can and should be terminated. This does not mean that the applicant needs to overcome the refusal within 1 year, but rather that they should make a valid attempt to overcome the refusal. The 1 year clock is reset each time the applicant makes a valid attempt to overcome the refusal, usually by making an appointment with the embassy or sending in the documents requested by the consular officer.
When are applicants required to repay the visa fees?
U.S. immigration law states that any applicant who cannot overcome a refusal within 1 year must pay a new application fee. This is true even if they have scheduled appointments with us within the last year, but have still been unable to overcome the refusal. This does not apply to applicants who receive an approved waiver for their ineligibility from U.S. Citizenship and Immigration Services or reaffirm cases, but it does apply to individuals who were previously ineligible due to drug use. Fees for immigrant visas changed in April 2012. The new fee for immigrant visa applications is $230 US for family-based petitions and $405 US for employment-based petitions.